So if Illinois' gun and magazine ban is upheld by the courts, what exactly are you going to be required to register with Illinois State Police? Well, a online publication, Mom at Arms, has a document internal to the Illinois State Police they got through the Freedom of Information Act that spells this out. Good morning, Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. It's now 6:12, and you can always follow me really anywhere. Live, of course, 92.7 FM. But you can follow me on YouTube where you can find video segments. Just search Bishop on Air. Subscribe. You can also follow me on Twitter, Bishop on Air, or Facebook as well, Bishop on Air. So several ways for you to get a hold of us here at the program. But let's get into this. Mom at Arms, who's been pretty adamant in their coverage. They also were one of the organizations that really elevated the issue of the $1 million that Governor J.B. Pritzker gave to each of two Illinois Supreme Court justices when they were candidates last year, and the questions about impropriety and possible conflicts of interest, which, by the way, we could see rear its head today with a ruling about the Safety Act, where the two justices were on the panel. And the question of if they recused themselves there was never officially brought up as it was in the gun ban challenge in front of the Illinois Supreme Court. But I imagine there's still going to be some critics questioning the conflicts of interest or possible conflicts of interest with that particular case. But anyways, Mom at Arms, their latest here, we'll go ahead and pull this up. They've got Illinois State Police gun ban enforcement memo and major concerns. So they obtained this through the Illinois Freedom of Information Act, and it's from January of come January 1st, 2024. This is what they found here. This is a law bulletin from earlier this year. They say January 10th, Illinois House and the Senate, they passed House Bill 5471. That's to Protect Illinois Communities Act, which becomes effective once the governor signed it. And we all know kind of the ins and outs of this particular measure. In particular, that it bans 170 plus semi-automatic rifles, shotguns, and pistols, but it also prohibits the future sale and possession of magazines of more than 15 for handguns and more than 10 for rifles. Plus, it has this registry component where if you in possession of one of these banned firearms before the law was enacted January 10th, you're grandfathered in, but you have to register those with Illinois State Police by January 1st of 2024. Also, one of the other aspects we've talked about just briefly was every October 1st, the state police can modify the list of firearms that need to be registered with Illinois State Police. So that could change every year. So that's a little small component of this. But this year, you've got state police. They're going to essentially get the registry launched on October 1st of this year in anticipation that January 1st comes around. That's the deadline for you to register and, go back to, what was it called, Freedom Week, whenever there was a injunction on the law from being enforced from the Southern District, about 6 days worth, where the law was held from being enforced. So they went into their firearms dealer and they purchased a semi-automatic rifle, for instance. And we heard from state police back then that those rifles or those semi-automatic firearms are not legal and cannot be registered because they weren't owned before the law was enacted January 10th. So there's still some very interesting legal problems with how this is all going to fall into place if the courts uphold the ban. Right now, though, the federal appeals court, they're sitting on the case. They heard it weeks ago, and we still have yet to get a determination as to when exactly we're going to see this case go to the Illinois Supreme Court, but that's all still at play here. But looking at what Illinois State Police are ultimately saying about the enforcement of this, the assault weapon attachments, the Illinois Criminal Code, by adding new provisions within the deadly weapon article. Specifically, it creates offenses for the sale, manufacture, delivery, import, transfer, carrying, possession, purchase, or use of. And of course, it's got the assault weapon attachment. Then you go further through, and Mom at Arms highlights other possession of requirement of possession and assault weapon attachments. Also have provided an endorsement affidavit signed under oath to the ISP no later than January 1st. They go through and they talk about who's exempt and so on. So these are just further guidance that the Illinois State Police offered up. So one thing that Mom at Arms interprets here is that all attachments would have to be registered, including dust covers, grips, springs, stocks, extractors, and all spare and add-on parts that you own. They're assault weapons, Mom at Arms interprets. So they say they need to be itemized and submitted to state police along with that gun that meets the banned criteria. So that Magpul VGF that you have lying around somewhere from 5 years ago, they say you better list that or you're breaking the law, and ISP views it no different than holding out or not registering your, quote, scary black guns. The AR detent that flew across your living room and you lost, well, that's an assault weapon component, they say, and if not listed, you're, in the eyes of the ISP, committing a violation of this law. So that's an interesting finding that Mom at Arms has highlighted, and you can find this again at mom-at-arms.com. mom-at-arms.com, where you can see this in more detail. But obviously, there's some substantial questions. The parts issue, I know that one of the plaintiffs' groups was actually very, very versed in challenging the state law on the issue of all of these parts for firearms that are essentially banned. Screws or springs or certain things that could be considered attachments. So there's a lot of concern about the vagueness of that and the enforcement of that. How do you exactly go about having to register all the springs and screws and whatnot? So obviously that's going to be a major issue down the road here. When is that going to be an issue? Not too sure, because you do have the other aspect of the challenge against Illinois' gun and magazine ban, and that is those who say it violates the Fifth Amendment right against self-incrimination, where you have a Fifth Amendment right to not incriminate yourself, to not tattle on yourself to the government. And the argument is the government bans a weapon, and then if you own that firearm that is banned by the legislature, then the legislature's compelling you under threat of criminal violation, a felony. If you don't register that and tell on yourself to the government that you own a banned weapon, then you are violating the law. That's compelling somebody to incriminate themselves, which there's a Fifth Amendment argument that has yet to be litigated in the courts. Could that be litigated here in the next 5.5 months that we have left of this year before the January 1st deadline to register these firearms with Illinois State Police if the law is not struck down by either the circuit courts with a injunction in place while it goes up to the appeals court all the way up to the U.S. Supreme Court? The trajectory of this obviously is very much at known and in flux, and something we'll definitely be keeping an eye on closely. But if you get a chance, go check out Mom at Arms. They've got the story with the documents of the internal, rule interpretation that Illinois State Police are working on. And I imagine that we'll hear a lot more about all of that in the near future. Because one thing, too, you have to consider is these rules have to go through the Joint Committee on Administrative Rules. So that'll give us a chance to see even in more detail what the rules that Illinois State Police are putting forth when it comes to the Protect Illinois Communities Act. All right, stay tuned. We got more coming up, including what's going on in other jurisdictions. Oregon has a case about firearm possession, and just across the way over in Indianapolis, there's a ordinance they filed, but it seems to be running afoul with that state's law. So stay tuned. We'll get to that next year with Springfield's Morning News on 92.7 WMAY, Springfield's News and Talk. And you can always chime in at 217-629-7970. Again, 217-629-7970. When we are live, you can call in 217-629-7970. So as we in Illinois await the outcome of the federal appeals court on the gun and magazine ban, as we await the Illinois Supreme Court ruling on a gun and magazine ban, there's a lot of action happening all across the country. Most recently, you've got a federal judge in Oregon that apparently has upheld a ballot initiative that passed there dealing with firearms regulations. So a federal judge in Oregon said that stricter gun safety rules are constitutional. But this is just a lower federal judge, an inferior judge, as the U.S. Constitution says. So expect this to go to the appeals court and possibly even all the way up to the U.S. Supreme Court, depending on which case gets there first, which, if you really think about it, you've got a case from Illinois that's already gotten to the U.S. Supreme Court. If you recall, Naperville, the challenge that Law Weapons has filed against Naperville, that was all the way up to the U.S. Supreme Court with a request for an emergency injunction. But since the appeals court took up the case and had an expedited docket, they went ahead and the Supreme Court said, well, we'll let the lower court deal with this. So whichever case gets to the U.S. Supreme Court first, I think really is going to be telling. But regardless, you have a case out of Oregon where essentially the law that voters approved, it bans, quote, large capacity magazines and requires a permit to purchase a firearm. And the federal judge there said all of that was approved by voters on ballot measure 114. The judge, Karen Immergott, found that banning large capacity magazines and requiring the purchase of firearms, quote, follows the nation's history and tradition of regulating uniquely dangerous features of weapons and firearms to protect public safety. This is after a week-long trial in this case. And of course, also after a year ago, the U.S. Supreme Court ruled that you can't require special permission for people to exercise their Second Amendment rights to carry firearms outside the home. But you've got the judge saying that certain magazine capacities are not commonly used for self-defense and that they're not protected by the Second Amendment, which seems to really just dismiss all of the other reasons people own or use firearms: hunting, target practice, whatever the case may be. The Second Amendment doesn't say anything about self-defense. It says for the security of a free nation. A well-regulated militia being necessary for the security of a free nation, a free state. The right of the people to keep and bear arms shall not be infringed. So it'll be interesting to see what happens in that case. One thing that is noted here, though, is that the law is still on hold, but this federal district judge down in Oregon did indeed side with the ballot measure that voters approved. Meanwhile, over in Indiana, an interesting case where the Indianapolis City Council has approved an ordinance that brings about some gun control measures, but it's not something that's enforceable because there's a state preemption law. So the Indianapolis City Council, they imposed a ban on, quote, assault weapons. They require lawful gun owners to possess a concealed carry license before they can carry a weapon in self-defense. It prohibits adults under the age of 21, so people who are 18, 19, and 20, from purchasing a gun. And you've got the concession from the Democrats in the Indianapolis City Council that say, they can't really enforce this because the state has a preemption law. Now the Attorney General of Indiana confirming that the new measure doesn't have a legal leg to stand on. So interesting to see the Indianapolis City Council move forward with such an idea. Obviously, it's not going to be enforceable. And if it is attempted to be enforced, then I imagine the Indiana Attorney General will come down on them. So, when we look at these instances across the country, you can see very much the question of the Second Amendment is an issue that's still at debate, and that's regardless of what the U.S. Supreme Court has ruled in several instances on these cases. All right, 217-629-7970. We got a call coming in. Let's go ahead and take that. Good morning. You're on WMAY.
Just a quick question. Does that expedited hearing on the gun law have anything to do with if it has to expedite when they put an answer out?
That's a great question. I don't know the answer to that. I speculate that no, it does not require them to expeditiously put out a ruling. So, yeah, they did the rocket docket, as they call it, right? They said we're going to have a sped up process of people filing their briefs, and we're going to have a hearing within like 3 or 4 weeks or whatever it was. That's quick for a federal appeals court. But as far as putting out that ruling, we don't know. We don't know when that ruling is going to come out.
Okay. Thank you.
Appreciate the call, 217-629-7970. And you got to think, we hope to get a ruling before too long so that if need be, it goes right up to the U.S. Supreme Court. Now, how quick the U.S. Supreme Court could take that up, could they conference this fall and maybe take it up internally and then just put out whatever, or are they going to have a hearing and then wait for, an entirely different, timeline down the road, months after the January 1st implementation for Illinois' registry? These are questions that we just we don't have the answer to yet. That's why we're still at a holding pattern for a lot of this. All right, it is Springfield's Morning News. I'm Greg Bishop. Follow me anywhere, Bishop on Air. Just search Bishop on Air, Twitter, Facebook, YouTube, and we can connect that way.